So I have an important update for you in the nationwide block against the ATF and their SBR/pistol brace rule. So let's talk about what is happening. Now, really quick before we jump into this video, I want to ask you guys for a little bit of a favor. I wanted to ask everybody who watches this video if you simply just hit that like button and maybe leave a comment, just any comment, even if it's just a comment saying that you're, commenting to fuel Al Gore's rhythm. I would really appreciate that. I want to see what that does for the algorithm, and I would love your guys' support. A lot of people actually won't like on the videos, so I want to just see what that does. Again, thank you guys so much for all of your support, and thank you for watching these videos. So like I mentioned in the intro, in this video, I have an important update with the ATF pistol brace case and the current nationwide block that's in place against that rule. The ATF just submitted their opening briefs to the Fifth Circuit, and their arguments are essentially that this nationwide block against the pistol brace rule needs to be reversed, that the lower court, that the judge there issued relief that is too expansive, there should not have been a nationwide vacatur of the rule, and also now they argue that this relief granted by the lower court essentially leads to an impermissible block on the payment of a tax, essentially that the NFA's tax requirement blocks this type of nationwide vacatur. Now, as you may recall in prior videos, Judge Reed O'Connor issued a decision on the merits of this case, essentially striking down the ATF's pistol brace rule entirely, and he vacated it nationwide. But now the ATF has appealed that decision up to the Fifth Circuit in the Mock versus Garland case. The ATF has now filed their opening brief, which asks for the Fifth Circuit to reverse that nationwide block. Originally in the Mock case, the Fifth Circuit found that the plaintiffs were in fact likely to succeed on the merits of their arguments, which were against the ATF, that the ATF violated the APA, because what happened here with the proposed rule and the final rule was that the final rule was not a logical outgrowth from the proposed rule. So after that, the Fifth Circuit then sent the case back down to Judge O'Connor, who issued a preliminary injunction finding that the ATF did violate the APA. Judge O'Connor then reviewed this case on a final merits and granted a motion for summary judgment in favor of the Mock plaintiffs, striking down the final rule completely nationwide. In his decision, Judge O'Connor stated that at the conclusion of the majority's careful analysis, they held that the final rule is properly characterized as a legislative rule, and it is relatively straightforward that the final rule was not a logical outgrowth of the proposed rule. Therefore, the final rule must be set aside as unlawful or otherwise remanded for appropriate remediation. Now, that decision was a huge win and has now set the stage for the Fifth Circuit Court of Appeals, a 3-judge panel, to review the final merits of this issue. In response to that new decision, the ATF first sought a stay from the lower court from Judge O'Connor, but that was denied. And now the ATF here has appealed up to the Fifth Circuit, but also importantly, they did not seek a stay from the Fifth Circuit, so that nationwide vacatur of the rule is going to remain in place at least until the Fifth Circuit rules on the merits of this case. So that's important for everybody. You have to know that the nationwide vacatur is still in place. Pistol braces are currently protected nationwide. And as a result of this appeal, the Fifth Circuit also decided to moot out all 6 cases that were up for preliminary injunction reviews, and they dismissed them, and they're proceeding forward only with the Mock case. Now, the ATF's opening brief asked for the Fifth Circuit to review 3 things. First, whether the plaintiffs are entitled to relief on their logical outgrowth claim. Second, whether the rule is arbitrary and capricious. And third, whether the district court's universal vacatur was impermissibly overbroad. The ATF argues in their brief that the district court erred in granting summary judgment to the plaintiffs on their claims that the rule failed to comport with the APA's notice and comment provisions and the APA's reasoned decision-making requirements. The ATF argues that the notice of proposed rulemaking provided sufficient notice to permit interested parties to comment, although the rule heeded commenters' concerns by declining to adopt the notice of proposed rulemaking's specific proposal. The proposed rule previewed the rule's reliance on objective evidence of intent and the specific probative evidence identified in the rule. So here what the ATF is pointing to is essentially they're arguing that the Judge O'Connor here came to the wrong conclusion, even though the Fifth Circuit told them that the rule did violate the logical outgrowth test. They also argue that the Fifth Circuit should abandon their prior determination that the rule violated the logical outgrowth test. The ATF then goes on to argue that the final rule did not violate that test. They argue that the proposed rule's report card system had themes and objectives and some identifiers of intent that then were carried over into the final rule. They claim that these concepts mean that there is enough consistency between the two rules, between the proposed rule and the final rule, to pass the logical outgrowth test. Now, if you don't understand what the critical debate here is, what they're talking about is under the APA, there has to be consistency between a proposed rule that we all comment on and a final rule. Now, you may recall that with the proposed rule here with pistol braces, there was a report card system where you would look at the characteristics of your firearm, add up points, and if it reached a certain threshold of points, well, then the ATF said that your firearm was an SBR. But with the final rule, they scrapped the report card system and went to a broader, more vague concept system where they had some general language about what would classify something as an SBR, but then left a ton of discretion to the ATF to find other, rationales or categories and other reasons why a firearm could be an SBR. Finally, the ATF argues that at the very least, the Fifth Circuit should remand this case back down to Judge O'Connor because they argue he cannot issue a universal vacatur of this rule. The ATF argues that Judge O'Connor exceeded his authority and he should have issued a more limited relief that was potentially only protecting these individual plaintiffs named in the mock case. The ATF also walks out their new favorite argument, which is the Tax Anti-Injunction Act, or the AIA, and they say that the AIA bars this type of universal relief and some sort of relief here that would essentially avoid the payment of a required tax under the NFA. So they're trying to use the NFA's tax requirement to say that this nationwide vacatur should be reversed. The ATF states in their brief that in all events, the district court erred in universally vacating the rule. Instead, any proper relief had to be tailored in two ways. First, proper relief cannot restrain ATF from applying the rule in the context of assessing and collecting the NFA's tax. They also state that the Tax Anti-Injunction Act, which generally prohibits suits for the purpose of restraining the assessment or collection of any tax, bars the universal vacatur entered by the district court. The NFA establishes a tax on the making and transfer of short-barreled rifles, and the district court's universal vacatur impermissibly interferes with the ATF's chosen method of assessing that tax. Now, if you've been following this channel for a while, you will know that the ATF first rolled out the AIA NFA tax argument back with the Made in Texas oppressor appeal that was in front of the Fifth Circuit. At that time, the ATF argued that the Made in Texas Oppressor Freedom lawsuit could not be brought because it would result in people avoiding paying a required tax under the NFA. And now here in the pistol brace case, it seems like the ATF is rolling out the same argument. They claim that the nationwide vacatur issued by Judge O'Connor was relief which violated the AIA. They claim that the nationwide vacatur should be struck down because you are required to pay a tax under the NFA and no form of relief can be granted which would stop that. So very interesting developments in this case. The ATF now is appealing to the Fifth Circuit. They're arguing that the NFA tax requirement should essentially strike down the decision down below, that the nationwide vacatur should be removed. And they also argue that the general APA arguments were invalid, that Judge O'Connor came to the wrong conclusion. And also in some ways they're arguing, or not in some ways, they're actually expressly arguing that the Fifth Circuit should go back on what they said prior, should reverse what they found, that this essentially is a likelihood on success on the merits argument, that yes, there was a violation of the logical outgrowth. They're saying that the Fifth Circuit should reverse even what they said prior. So very interesting developments. We'll see how this plays out. The plaintiffs now are going to respond to those ATF arguments, so we'll be looking for those as well. And if anything else changes, if anything else develops, I will let you guys know. Also, if you like this video, and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.